question is whether this is constitutionally valid or whether it is violating the basic structure of the constitution. And the concept of basic structure and how it has evolved, all you know. Now, when I look at this judgment, I have certain problems. The problems, as I see it, are these two. One, this reflects a lack of understanding of the idea of a legal category. This judgment, I mean, the majority judgment, indicate or suggest the lack of understanding of the idea of a legal category. What is a legal category is the question that I would discuss. Second, non-recognition of the value of factual establishment through acceptable research methods. What I say is that law is closely connected with facts and only with facts, and the concern of legal decision should be based on empirically proved facts. And the issue here, or the case as we discuss, has not given much concern to the empirically established facts. So these are two problems that I conceive. Now, legally speaking, what are the problems that we can see? One is that this particular amendment, 103rd amendment, is affirming an action for a privileged forward caste. EWS, though, tries to speak apparently that it is a reservation for economically weaker section. The notification issued by the state government, Kerala state government, is exclusively for Savarna communities. So EW means exclusive Savarna reservation, in fact. Second problem is that the decision is based on a wrong assumption that reservation is an exception to equality. 16.4 is an exception to 14, 15.1 and 16.1. So this is a wrong assumption. Reservation is not an exception to equality, but rather it facilitates equality or promote equality. And third one is that it assumes that this new reservation through Article 103 is for sections not so far receiving the benefit of reservation. That is a wrong assumption. So it is based on these three assumptions the decision has been made or the judgment has been made. Now I'll explain. So Professor was talking about the equality code. So before that, let me just explain what is a constitution. Why do we need a constitution? Constitution is a document which structures the society, Indian society. So through constitution, our aim is this. We want to structure a new society. You can see from the wording of the constitution itself. We the people having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and other things comes in. So what we want to do to construct a new India or to constitute a new India is the question before the constitution. And the constitution very clearly at the beginning itself in the preamble say that we must respect certain virtues or values. Equality, liberty, justice, social, economic and political, and fraternity. Rule of law, all other things comes in. But the most important is equality, fraternity, and liberty. Now, when we think about equality, it is the equality of opportunity. Equality of opportunity, which is a primary value. Now, why the constitution is giving significance to equality of opportunity, you must understand. Because the social structure we had before, it is not this, the freedom struggle is not only against Britishers. The freedom struggle was against a social structure which was existing before independence. What was that social structure? The social structure that doesn't give equality of opportunity to a substantial segment of people. More than 80% of the people were lacking freedom in the real sense. They were not given education. They were not given employment. They were not given legal power. They were not given political power positions. Such was the social structure which reserved higher education, higher posts for very few privileged upper caste communities. This is a reality that we need to recognize. We never talk about this. So it is this Savarna social structure which our constitution want to destroy. And the constitution in turn want to replace an egalitarian social structure. So what the constitution can do, or what the constitution say, what are the principles the constitution advance for that purpose? The constitution understand that only few community, privileged community, have got opportunities in educational institutions, in public employment, and they are having the power. Now, how can we overcome this? The constitution, it is therefore for the purpose, and what is happening? What is the result of this? What is the result of the privileges of the few? The result is that excessive representation of those communities. What are those communities is a question of fact that you need to identify through empirical observation. In Kerala, you can observe which is the community or which are the communities that is having excessive representation. You must ask the question, okay, now, if a particular community or few communities are having excessive representation, can you say that it is a democratic society? It is not a democratic society. That is not the meaning of democracy. But our constitution wants India to be a democratic society. So what we need to do to be a democratic society? We want representation. Whose representation? That is the question. Whose representation a democratic society want? The representation of all the communities which are so far unrepresented in educational institutions, in public employment, and in political power structures. And now you need to ask the question, why this majority of these people are not being represented? Because of an ideology, because of this Savarna ideology, which consider human being to be unequals, which consider certain human being to be superior and certain others human beings to be inferior. Science never say certain people are superior and certain people are inferior. Science say that people are different. But Savarna ideologies say that certain people are superior and certain other people are inferior. And therefore, this inferior people should not be educated. This inferior people should not be given employment, particularly higher posts. And these people should not be ministers or the leaders. They do not have that quality. This is the context that you need to understand before you need to understand the constitution. Now, the constitution say that this is not the society that we want. We want an egalitarian society. We want a society in which there is representation. So, we have provided for reservation. Reservation for unrepresented communities. In fact, this reservation, you must understand, right to reservation, you must understand as right to representation. Now, it is this lack of understanding which is resulting in this kind of absurd judgments, according to me. If you understand reservation as right of representation, everything is clear. Then now the question is, who should get representation? The persons who are historically excluded from representation without any mistake on their part. It is only because of ideological reasons a particular group has been excluded from representation. Now, this is the context that I want to make. Now, let us say, so reservation has been provided under Article 16.4, as Safi sir has said. 16.4 say that unrepresented educationally and socially backward community or backward classes of citizens should get reservation. It's very clear. Socially and educationally backward class of citizens and unrepresented. These two conditions has to be satisfied. Now the question is how we can determine the backwardness, how we can determine who is socially and educationally backward. What are the criteria that has to be met with to say that a person is particularly socially and educationally backward? Now it is here that we need to have certain empirical data obtained through research method, acceptable research method, and to say that based on this criteria, we can identify socially and educationally backward communities, or we can identify the criteria of backwardness. It is exactly what Mandal Commission has did. They have identified 11 criteria, which included social, political, as well as economic criteria. So please don't be under the impression that economic criteria was not considered. Mandal Commission has considered social criteria as well as political criteria and also economic criteria. Family income, lack of opportunities in economy are the economic criteria that has been considered. Educational criteria has been considered and social criteria has been considered. And based on this criteria, any class of citizen can be identified as a backward class of citizen. Brahmins can be backward class of citizen if these criteria are met with. Nayars, Nambudiris, or Nambiyars can be backward class of citizen if these criteria are met with, because backward class of citizen is not a caste, it is a class. A caste can be within the class. So now the problem is that Savarna ideology cannot think in terms of legal categories. They can think only in terms of caste. They think that backward class of citizen being certain castes, and we are not in that. A Brahmanistic claim would be this: I cannot be backward class of citizen. I am always forward class of citizen, which is wrong. So Constitution gives a very, very empty formula, the content of which has to be filled based on factual criteria. So it is this factual criteria that the Mandal Commission has identified, and various other commission also has identified. And based on the criteria, any individual or any group of citizens, if they meet with or fulfill those criteria, can be considered to be a backward class of citizen. Now, what is the problem here? The problem is that a Savarna perspective cannot understand this, because when they look at an individual, they can only see a caste. If they look at me, they will ask the question, what is your caste? And they can understand me only belonging to a particular caste. That is not a legal way of thinking. Okay. Now, so my point is this: backwardness or backward class of citizen is identified based on certain set of criteria, which includes social backwardness, educational backwardness, as well as economic backwardness. Now, when you think about economic backwardness, please don't confuse it with financial backwardness. It is not an individual's income that matters. If you are considering a person poor based on his financial status, that is not an economic criteria that is applied, but it is a financial criteria. So we also need to understand that when we think about backwardness, social and educational backwardness of a class of citizens, it is not the financial inability that counts, but it is economic criteria. That means the family income and the inability to participate in the market and various other economic disadvantages considerations. Now, next is that who are the class of citizens who could be considered to be backward? It is not only caste. Caste could be a class. Similarly, it could be a woman. Woman could be considered to be backward class of citizen. Sports persons could be considered to be backward class of citizens. Transgender persons could be considered to be backward class of persons, provided the criteria of backwardness they meet. They are not backward because they are transgender. They are backward because they meet with the requirements or the criteria that is fixed for defining backwardness. So now, so what is happening here? In 103rd Amendment, through 103rd Amendment, what is happening? Through 103rd Amendment, and a new category is created, economic weaker section. In clause 16, why? Clause 16 or Article 16 is for reservation, and reservation is given for representation. Now, you need to ask the question whether, two questions you need to ask, whether economically weaker section can be identified as a group, and whether economically weaker section is unrepresented in education, public employment, and political power structures. And also, as Professor has rightly said, whether this economically weaker section category is exclusively based on economic criteria. So you must understand that if you look at the Kerala notification, government notification, only upper castes or forward castes identified as economically weaker section, excluding SC, ST and OBC, as you know. So if SC, ST and OBC are not weaker section, then who else? And you are identifying few upper caste communities as economically weaker section. It is purely based on caste. That classification is purely based on caste, which is prohibited by the Constitution. So how can you say that it is not against the constitutional requirement? I don't understand. It is clearly an upper caste selection. That notification is an upper caste selection. But what is happening? Only a creamy layer is excluded. It says that, okay, but within this class, the class of upper caste, those who have a particular income level is excluded. That means creamy layer is excluded. Below the creamy layer, all the upper castes that is enlisted in the notification would get economically weaker section reservation. So in the judgment, the real issue was this. It is not excluding SC, ST, OBC, but rather it is including certain individuals purely based on their caste for the benefit of a constitutional reservation scheme. This is exactly what was happening. But they are not telling, because they want to cheat us, according to me. It is a deception, clear deception, without stating directly what is happening. What is happening is a back window, opening up of the door for upper caste or forward caste communities, and saying that it is exclusively for a category of people economically weaker. If it is for a category of people economically weaker, quite naturally, scheduled caste, OBC, scheduled tribes would be included within that category. And if you exclude creamy layer also, SC, ST, OBC creamy layer would be excluded, but still then they would constitute an economically weaker section. The judges have never gone into this question. They have formulated the issues indirectly by excluding, even though it was asked for by Dr. G. Mohan Gopal sir in the open court. You can see the video of his argumentation in the Supreme Court. It is one of the finest arguments I have ever seen. Unfortunately, 3 judges could not understand, or rather, they were in favor of economically weaker section by a flawed reasoning of the Constitution. Now, what is the effect? What is the anticipated effect? I have only just 5 more minutes. What is the anticipated effect? It divided the population into mutually exclusive compartments. This judgment is for the first time offering a constitutional privilege for upper caste, forward caste communities. And you will get economically weaker section reservation only if you belong to upper caste. The precondition for exclusive, the condition for economic weaker section reservation is that you should belong to upper caste. If you are not in the upper caste, you will not get EWS reservation. Once you are upper caste, then the income limit would be tested. Whether you are creamy layer or not would be tested. But the sole condition for claiming EWS reservation is that you should be included within an upper caste or forward caste that is enlisted in the notification, which is clearly unconstitutional. Now, how the reasoning of the judgment is trying to overcome? They are trying to overcome by saying that these are poor, these are underprivileged, these are lacking resources. Of course, we must help them. I'm not saying that we should not help them. We must help them, but not through reservation, which is for representation. It is not representation that they lack. They lack only money. They lack finance. They don't have money. They have enough land. They have enough, resources with them. Most of them have enough resources with them. They lack money. Money should be given. Financial aid should be given, and let them repay the financial. It is not because of any historical reason that this communities has been deprived. It is not deprivation. It is a privilege, constitutional privilege of representation given for financial losers, which is clearly wrong according to the philosophy of the Constitution. Because of the lack of time, I'm just stopping. So maybe I can answer with the question and answer session. Thank you.
Thank you, sir. Thank you, sir, for the wonderful insight. So we're going to move forward with the question answer session. The participants for the Q&A sessions may ask the question via the microphone, or they can also use the chat box for the same as well. Well, the participants list for the Q&A session is as follows. We have at first Kavya from LJRF Voice. All right, so Kavya has asked her question. The question asked by Kavya is
to what extent it is applicable? Yeah, that is a good question. See, that is one confusion that we have. You must understand one thing. So why we conduct this kind of discussion? According to me, it is because of our constitutional rights. We have a freedom of speech and expression. Why this freedom of speech and expression is given to all individuals, all citizens? Because we want criticism. See, we must have a very different understanding of the society. That's what I'm saying. We want to constitute a new India. Our old India, which we want to change, does not encourage criticism. They want loyalty. They want obedience. They don't want challenging. They don't like questioning. They don't like criticizing. But what we want through the Constitution is a very critical society which would challenge, which would question, which would ask for answers, reasonable answers, and which would, engage in different kinds of conflicts and, debates. Now, See, we have a legal system wherein we have a set of rules which talks about precedent system, in which we say that you have to obey, or you have to pursue, you have to comply with the judgments of the Supreme Court. Fine, that could be there for a time being because of enforcement of law, but that doesn't mean that you should not criticize. We must criticize. It is our job and responsibility to criticize a decision. It is through this constant exchange of ideas that mistakes could be corrected. Maybe because it is coming from a higher bench of the Supreme Court, other courts may follow. But it is not compulsory. It is possible for us to distinguish a particular case given a different context. And by reasoning, offering a reasoning, we can deviate from the precedents as well, is it not? That is what the system of precedents say. Precedent is not an absolutely binding, iron rod. It is, in fact, it has the potential for deviating, provided you have a justifiable reasoning for doing so. But now the question is that if you want to deviate, then you should have the ability to think. Critical thinking is required there also. So we must continue this exercise of critically looking at things and trying to find out. And this is a mental activity. In fact, whether you are right or wrong, you must be able to identify. You must wear different caps, and you must be able to identify whatever problems that you can see from different perspectives, and let these perspectives conflict with each other. Let this the conflicting opinions table together, and then there will emerge a new solution for the problem. So when you ask the question, of course, applying technical rules, this judgment may be binding upon other courts and executive, but still then we have room for criticism, and we must try to change within the legal limits. I think a review has been filed now against this judgment in the Supreme Court itself. However, we have room for political dissent. We have room for critical discussions, as long as this is a democracy, and our constitution want this to be a democracy, and the constitution has given us the freedom of speech and expression. Thank you.
Yes, I also support Vidyuth sir view, because in my point of view, it does not satisfy the judicial standards and constitutional standard. As I support Vidyuth sir statement, because he already mentioned a particular statement. I think you have a better understanding of that statement, that he said it is a fraud reasoning of the constitution, which is something which is mentioned in the judgment. So we have to look into the fraud on constitution is a concept where the judiciary is interpreting the constitution in a way that it is destroying the basic content of the constitution, which was formulated by the judiciary in its earlier judgment and judgment, especially in this particular case, in terms of reservation as well as in terms of basic structure of the constitution. Thank you.
Thank you, sir. Next up, we have Deepthi from the Center for Arbitration.
Yeah, thank you, Nitu. I will be putting my question on the chat box right now.
Okay, Deepthi. The question posed by Deepthi is, India is the largest democratic country which still face troubles with caste system. It may be considered as the weakest part of the country to fly off to economic justice. My question is that why can't we eradicate reservation for any caste? Why can't jurisdiction look upon the value of social and economic justice?
Yeah, that is also a good question. Answer has been already given by Sufisar. See, now this is a practice which has been practiced in India for thousands of years. And benefits, see, you must understand that this is purely an ideological construction. Nowhere in the world you can see an institution called caste except in India. Caste is a social institution deliberately created by Brahmins for their benefits, no doubt. They have benefited out of it. All the labor for them has been done by the lower castes, and they, that memorized certain things without making any effort. They earned all the material benefits they wanted. So it is a social institution for the benefit of upper castes. Lower castes has no role. They are slaves working for the upper castes. Okay. Now, having followed this social institution for a long time, upper castes has accumulated all the resources. That's what we say. Sufisar has said that quotation from that judgment. When two horses has to compete, two horses must start from the same starting line, is it not? You know, upper caste horse is far front and lower caste is far behind, and you are saying that now we will stop all these things. Now let us start social justice and economic justice. What is the social justice and economic justice you are referring to? Unless there is a parallel field, unless there is a level playing field. Now, there is no level playing field when we have got independence. Reservation or right to representation is a measure for making it a level playing field. Let there be a level playing field, then we will start competing. Our constitutional scheme is exactly that. Now, when you talk about 50% of, 50% exclusive for competition and 50% for reservation. Why this 50%? Because the fundamental principle is equality of opportunity, no doubt. We want equality of opportunity of all. All should compete with each other. But the time is not ripe enough for that because of the so far existed and still existing caste system. So social justice and economic justice includes representation. And reservation is only representation. You just forget about all the false narrative that has been offered to you. That what is the narrative that has been offered to you? The people coming by reservation are inefficient, does not have merit. Who said? Who said? Now EWS, why this hurry for reservation? Within 6 months, all procedures has been completed. Now reservation is completed in every educational institution. EWS is gaining 10% reservation. No problem for them. No loss of efficiency. No loss of merit. Now you look at empirically. That's what I'm saying. I'm asking you to look at the facts. You look at the facts. What is the rank of the last Savarna person who ended in the educational institutions? Very, very low. Where is your argument of inefficiency? Where is your argument of merit loss? Now, please understand, this is only false narrative. What is this people want? They want exclusive reservation for them. You must understand that reservation is not the creation of constitution. Reservation has been created by Brahmins. In Vedic time, from Vedic time, education was reserved for Brahmins, exclusively for Brahmins. No one has the ability or competency to learn, educate, because it was reserved for Brahmins. Higher posts were reserved for Brahmins. No one could become priest. Even now in Sabarimala, male Shanti could only be Kerala Brahmins. Why? It is reserved for them. That reservation is not at all a problem. Now, why this reservation in the constitution is a problem? Because this is not reservation. This is right to representation. all OBC, SC, ST, and other communities so far underrepresented is getting jobs, is getting educational facilities, is getting power. That is a problem. That is a Savarna ideology, which cannot withstand other people getting representation. Please understand this. And this is social justice and economic justice. Right to representation or reservation, constitutional reservation, is a measure of social justice and economic justice. It is not opposite to that. Please change that attitude and change that view. Thank you.
Yeah, I think with this sir clearly explained it. And one more point, only one more point that I want to add is that the Constitution does not prescribe anything about caste. Even when you look into Mandal Commission, the main area of focus was not caste; it is a class. And none of the constitutional provision promotes caste, but every provision of the Constitution prevent discrimination on the basis of caste. So actually the spirit of the Constitution is actually the spirit of the Ambedkar, which he mentioned in the books Annihilation of Caste. But the only amendment in the Constitution which promote caste is, as Vidyuth sir mentioned, is 203 amendment. That is the only thing that I want to say to add for your question. Thank you very much.
I'll add one more thing because it is a very, very valid question. See, you must understand that caste is only a Savarna institution. Avarnas don't have an institution of caste. They have only Swadandra Samudayam. There is no caste. It is in fact, can I speak in Malayalam? Okay, fine. I'll use English. See, now what is the problem is that this Brahmanistic Savarna ideology has crept into the mind of all. The psychology, it is a social psyche. Now we consider Brahmins to be the model. Even Avarnas, some of the Avarnas consider Brahmins to be with the model that we want to strive to become Brahmins. Even Suresh Gopi was saying, Suresh Gopi himself was saying that next birth, I want to be a Brahmin. Because this is an ideal which is created by them. But normally, Avarna is against this Savarna ideology because Avarnas has a very, 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 egalitarian philosophy for themselves. Because that was the Adi Dravida philosophy which existed in India, which was replaced by the Vedic Savarna philosophy, which is sectarian, which is divisive. What I would suggest is that please bring in back the beautiful Avarna ideology of India, which prescribe equality, liberty, and fraternity, which is there in the Constitution. In fact, this Constitution is suggesting Avarna ideology, and it wanted to destroy Savarna ideology. So rather than, as you suggested, eradication of reservation for any caste, I would suggest annihilation of caste, as suggested by Ambedkar. We don't want reservation for any caste, but we must eradicate caste itself. What is the need for caste? If you say that caste is required, maybe because you believe that caste is a social group which has, some, particular characteristics which it can claim exclusively for itself. Annihilation of caste is the solution for India, according to me. Thank you.
Yeah. So actually, I want to ask you one more question. Sorry to interrupt you in between. Yeah. So I got the point what you have said, and I'm extremely agreeing with that point also. But when actually my term was to, when we are saying that we are Indian, that means we are, we consider that beyond caste and all, we are equal as a human being. When we fight for human rights, why we are taking this reservation as a representation for some class or community? Still, we are facing troubles for tribal women or men who are still not getting that proper education that should be provided from the government, even for the constitution or for the legislation. this political playing legislation are making more inputs of such kind of such kind of thing to make their impression to get the votes. That's what I want to convey. Like I want to ask you for
Yeah,
that.
yeah. Actually, your answer for your question is specifically mentioned in Indira Sahini case. You just read that Indira Sahini judgment, you will understand. Thank you very much.
Okay, sir. Okay, sir.
I'll tell
Thank
one
you.
more thing, Deepti. Deepti,
Yes, sir.
actually, if we want to solve a problem, we must
Mhm.
identify the root cause. We shouldn't beat around the bush. We should not look here and there. Please be very clear. I appreciate Ambedkar for his clarity of thought. He identified the precise problem of India. It is casteism, Savarna ideology. No doubt about it. No doubt. 100% clearly he said. Casteism is the biggest problem in India. Everyone, though they speak humanity, they are casteist. Most of the people. You look at your own family, or a substantial number of your own family and your neighborhood,
Yeah.
whom your parents married,
Mhm.
who your cousins marry. Why they are not marrying outside? They believe in caste. And you ask the question, what is the problem if you marry outside? Then you will get the story of purity and pollution.
Yeah.
Somehow subconsciously it is there. This particular factor is the single most factor destroying India, I would say. Because you cannot, the quality of an individual, you do not consider him as an individual, as a human being. You consider him as a person belonging to a caste. And you are attributing inferiority or superiority according to his caste.
Mhm.
This is what exactly you need to remove, my dear. Otherwise, law
Mhm.
can do nothing. Law is only an instrument which would work. That is why Ambedkar said that this constitution is okay, it is only a form. But whether it could be workable depends upon the people who works it. So it is your attitude, your mentality that should be changed ultimately. Law
Yeah.
has all these things. See, woman could be backward class of citizen. As I said, if all these criteria are met with, women are backward class of citizen. Women are
Mhm.
transgenders are backward class of citizen. But now what is our public conscience? Our consciousness or our idea is that only certain caste, which according to the Savarna ideology, belongs to backward caste is backward class, which is wrong. This constitutional backward class is not castes. That's why I said even Brahmins could be socially and educationally backward class. Who knows? Sometimes within few years, this Brahmin community could meet with all these requirements. Then they will also get the protection of the constitution.
Yeah.
That is the beauty of our constitution. This constitution is caste free, caste neutral. It is class conscious. But this Savarna ideologist could not understand this because they can think only in terms of caste. That is the problem. And what if such persons are judges?
Yeah. Got.
Now, this is the most important question. As a law student, please be conscious of our constitutional ideals. Please read our preamble 100 times to understand what are the values it want to cherish and what is the social structure that we want to realize. And please be like that as an individual. It is quite possible for you to be like that, provided you have an attitude and you can challenge the Savarna ideology. Ambedkar has
Yeah.
clearly identified Savarna ideology and casteism as the single most problem destroying India. I am also of that opinion.
Yes,
Thank you.
same here. Same here, sir. Thank you. Thanks a lot.
Thank you, sir. I call upon Nafia Nazim from the Center for Probation for the last question. The question posed by Nafia is, since there is a growing objection among the meritorious students from sections of society not included in reservation for being denied opportunity even after giving their best shot. Wouldn't it be better if the court recommended to keep up the 50% cap as held in the case of Indra Sawhney and to include this 10% within that 50% of reservation for EWS if needed at all?
That is also an interesting question. Now see, what we argue is that EWS as a special category is not required at all. If at all you are creating an EWS category, then that EWS category must include SC, ST and OBC within it, based on the economic criteria that would be applicable. See, what is the criteria that they are fixing? Family income and other economic disadvantages, indicators of economic disadvantages. And Kerala government notification fixed this criteria like who has less than 2 lakh income, 1,000 square feet house, and 2 acres, 2 acres of land. By any standard, we will consider this to be a rich man, or at least a middle class man who is not a poor man. If at all this is the standard of poverty, then why do you want to include only Savarna communities within that category? Is the question. Now, first point is that EWS should not be there. Or if at all EWS is there, then that EWS should include all economically weaker sections, irrespective of caste and community. Now, this is a good question. Now, why we have 50% and why other 50%? See, this is based on a census. So they have relied upon 1961 caste census. Mandal Commission has relied upon caste census and census of conducted by different organizations. Unless and until we have caste census, it is not possible for us to understand the reality of representation, excessive representation as well as non-representation. Now, who is opposing caste census? Only upper community, forward communities. Why? They know they have excessive representation. That is why they are opposing. See, in 1881, we have started caste census. 1931, we have stopped it. Why we have stopped it? Because there is evidence now. Evidence of excessive representation of few communities and non-representation of the major communities. So if this is the case, then this percentage should be fixed based on evidence and based on the proportionality of the people, of these communities. In Kerala, what if 70% of the people are backward community? How can I give only 50% for 80% of people? What if EWS community is only 3% or 5%? How can you give 10% of reservation for only this 5% of people? Quite unjust, is it not? Unfair, is it not? So if at all you want to give representation, that representation should be proportional to their demography. Then what is required? We want a census. You ask the government to conduct a caste census. Let us have a clear idea. How many people are there belonging to this particular castes? And how many are represented? See, you have referred to meritorious students. What is the meaning of this meritorious student? How is the merit of a student evaluated, assessed? Based on a single examination or what? Do you think that based on the mark of a single examination, the merit of a student can be assessed? What a nonsense is this? This is a false narrative of, again, by this, by believing this Savarna ideological stories. I don't think that my merit can be assessed by a single examination. What about the experience of that person? What about experience of my person as a person? How can you assess my experience? What about the courage and that I got through my own life experiences? What about my personal experience in the particular field? Or if you want to appoint a director of an agricultural department, would you choose a person who got higher marks in an examination, or would you choose a person who has actual experience in the field, who can plow, who can seed, who can sow, and who can find out solutions on the field? Merit is a very, very complex, controversial concept. Don't understand merit based on the marks of a single examination. You must understand the concept of a merit in a more elaborated, detailed way. We must have a very systematic scheme for evaluating the merit of individuals, which is not a single examination scheme as existing today. Please don't be under the impression that if you got 70% marks for a single examination, how evaluation is conducted is also matters. How do you know that evaluation is false proof? How do you know that evaluation is conducted on a very, very strict, that standards? Yeah.
Yes, I think we can, lack of time constraint, we can wind up the section. And if you have any other queries, you please communicate. I think convener's phone number is there, so you can communicate it, and we will clarify all your doubts, because this is a very important constitutional issue in various
Sir, one
aspects.
question, please, sir.
Which we had already discussed. It's a legal as well as its political, social aspect. And Vidyuth sir is a person who have a better understanding of this particular topic because of many reasons. And he has a close association with Mohan Gopal sir, and I think and many people having a better understanding of the problem of the society, and they are fighting for the noble cause, which is actually the spirit of the constitution. So therefore, I think, yeah, thank you very much.
Give a very short message to the students who have participated. Please refer to right to representation, the expression right to representation instead of right to reservation. Then everything is clear. Your confusion is because, I'll tell you, just 1 minute, okay? Just avoid the habit of thinking that those who come on reservation are meritless, inefficient, and which does not have any value. It is nonsense. They have all the minimum conditions prescribed. You see, a person cannot be taken on reservation if he does not pass at least with a minimum mark of the examination. Okay, and it is not the marks that should be the concern. And please understand that reservation is right to representation. Yes.
Sir, actually, Akshay.
Yes, sir. You can ask the question.
Yeah, definitely. So, Akshay, please ask your question.
Sir, before coming to the class, I just went through some researches in art, and I find out that in the judicial system itself, there have been, as you said, like there have been a Savarna social structure just in the judicial system itself. We can see that clearly by we can just analyze all the since from it's been 70 years, and for the first 3 decades there have been no other communities at all, and after that till now till date there have been no especially no ST category man or women haven't came at that position in Supreme Court and all. And and by giving this EWS reservation, are they the judicial system itself is so complicated by this caste system and discrimination? Are they really going to provide the social and economic justice? Are they really going to do this?
No, see, that is why Akshaya, I said, you open up your eyes, you can see. But if you believe in the false stories, Brahmins and upper castes are the most efficient people in the world, whole world. They are superior. You ask the question. Yeah.
Sir, I'm not telling like they are like the lighted one or something like that. I'm saying like there have been researches and various studies have found out that the economic strategy of India, like these people are having, like upper caste people are having most economic resources, all
Yes.
social resources and everything within their hand.
Yeah,
And
that's what I said. It is quite natural. It is quite natural because that is why they have created this system. And they want to maintain the system at any cost because they are the beneficiaries. See, it is the other people who are on the receiving end who must understand that. And you know that the constitution is a classic document which want to challenge this structure and to restructure Indian society and to construct a new structure. And lawyers has a leading role to play for that purpose. That is what you must understand. That should be the take-home point I would like to give. So don't take everything for granted. Judges may be wrong, teachers may be wrong, lawyers may be wrong. You must have the ability to identify for yourself by your own analysis and search what is right and wrong. So you must all develop critical thinking skills, research skills, and do your own research for this cause and come up with your own findings and struggle for changing this social structure. Struggle is the only solution for changing. Without struggle, no solution. No would come and give you solution. You have to struggle for yourself. So this is the concluding message I want to give. Say that right to reservation is right to representation. So we must identify who are unrepresented. For that, we need to conduct survey, census, and based on the findings of that survey and census, reservation should be given to as many unrepresented communities as possible. That should be the solution. Thank you.
Different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional